Welcome to class. Today we'll be discussing about the intellectual property and business protection. Intellectual property and business protection. And in this competitive global business environment, intellectual property is actually a vital asset for complaints seeking a sustainable advantage. And it's very important to look into that, and that's why we'll be looking at the foundational principles of intellectual property law and its critical role in safeguarding intangible assets that drives innovation, brand identity, and market value. So I want you to follow as we look into them one after the other. The overview of intellectual law. Intellectual law, property law governs the protection of creations of the mind, ranging from invention and artistic work to symbols and proprietary knowledge. Unlike physical property, the intellectual property is intangible, with its value often stemming from uniqueness and revenue generating potentials. So intellectual property law grants creators exclusive rights to use, reproduce, or commercialize their creations for a period, encouraging innovation and creativity. And the primary reason for this is to ensure balance creators and the public's interest. And by granting temporary monopolies, the law incentivized innovation and economic growth, eventually returning creation to the public domain. And for businesses, this framework protects investment in branding, product development, technology, and proprietary information, preventing imitation and unauthorized exploitation. What are the types of intellectual property? The first one that we'll be looking into is the trademark, and this is it protects recognizable sign, designs, word, or symbols that distinguishes goods or services, and it is acquired through registration or use, and they are critical for branding and consumer recognition. Recognition. Patent is another one, and this actually grants exclusive rights to inventors for a limited time, usually like 20 years, to make, use, sell, or license an invention, and it must be novel, non-obvious, and useful. And another one is copyrights, which protect original, literary, artistic, musical, and dramatic work, including software. It arises automatically upon creation and fixation in tangible form. And lastly, we have the trade secret, and this is the confidential business information providing a competitive edge, such as formulas or processes. And protection relies on maintaining secrecy through confidentiality agreements. As per business name and trademark, we need to actually look into that. When we talk about business name, this is the official name under which a company is registered for legal and administrative purpose. And we've talked about business name in few slides, few presentations past. And registration provides legal recognition to operate, but does not grant exclusive commercial right or prevent similar names. So registered, it's actually registered with the National or Regional Business Registry and focusing on availability within the jurisdiction. And there is limited protection against name duplication. And that is why it is essential that we look into trademark. And this is a distinctive sign, word, and logo that identifies and distinguishes goods or services in the market, just like we've explained. And it represents the commercial brand identity and is crucial for consumer recognition, and this is um, registered through the intellectual property offices, which assess distinctiveness and potential confusion with existing marks, and it offers exclusive rights and is legally enforceable against infringers. Looking at intellectual property registration, the process, uh, looking at some of the countries, um, the registration provides legal recognition and protection, with processes varying by jurisdiction, but often adhering to international standards like that of the Paris Convention and TRIPS Agreement. And for Nigeria, trademark, patents, and industrial designs are registered with the Trademark, Patent, and Design Registry, while the copyright is automatic, but voluntary registration with the uh, Nigerian Copyright Commission (NCC) is encouraged. For the United Kingdom Intellectual Property Office manages trademark and patents, while copyright is automatically granted upon creation. And for United States, the USPTO handles trademarks and patents, and copyrights are registered with the US Copyright Office, though protection is automatic upon creation. For the European Union and the EU IPO handles EU trademark uh, and registered community designs RCD for all member states. And patent protection is managed by the European Patent Office, EPO. International Intellectual Property System. It's actually international treaties and system streamlines IP protection across borders, crucial for business operating globally. So we have a number of them: the Madrid Protocol, we have the Patent Cooperation Treaty, and we have the Berne Convention. For the Madrid Protocol, it actually enabled international trademark registration through a single application filed with the WIPO, signifying the process for businesses seeking protection in multiple countries. The Patent Cooperation Treaty allows inventors to seek patent protection simultaneously in multiple countries with a single international application, deferring national filing decision. And for the Berne Convention, it ensures automatic copyright protection in member countries without the need for formal registration, promoting international recognition of literary and artistic work. We have the legal enforcement and intellectual property infringement, and IP rights are only effective with robust enforcement mechanism. An infringement occurs when the intellectual property is unlawfully used without permission, undermining its commercial and reputational value. And we have types of infringement, which is trademark infringement, patent infringement, we have the copyright infringement, and we have the trade secret misappropriation. And what are the legal remedies? The remedies are cease and desist letters, which is informal demand to stop unlawful activities. Also, another one is civil litigation, and this is an injunction that is court order to halt violation and damages which can come in form of monetary compensation. And criminal sanction also is another remedy, where fine or imprisonment for severe cases like large-scale counterfeiting comes in. And the last is the delivery of and destruction, where the court orders to seize and destroy infringing goods. Intellectual property, as in a way of concluding, is a cornerstone of modern business strategy, providing legal protection for innovation, brands, and creative work. And we've seen the types of IP, which are the trademarks, the patents, the copyrights, and the trade secrets. We've also looked at the processes of registration, and we've also looked into the enforcement, stating that enforcement is actually key, and there is need to actually be proactive also in management, where business must proactively manage their intellectual property portfolios to mitigate risk, enhance competitiveness, and maximize commercial opportunity. Next class, we will be looking also, we'll be taking another thing we need to note. And by then, I hope that you would have taken the time to go through and read. Thank you.